Good evening, viewers. Welcome to another edition of Legal Hour. My name is MC Chaka. I'm your host for this insightful and educative program that we bring to you, especially on Tuesdays and on Thursdays. So a lot of people might be wondering why Chaka is here on Thursday. We do the program on Tuesdays and Thursdays. So Tuesday we did the tree version, and that was hosted by lawyer or solicitor Thomas Beyebenwo. And today we're going to do the English version. So we can do it either ways. We do it twice a week. So I hope you take note of that. Tonight we've got a very interesting and educative and exciting topic, obviously, to discuss. We're going to talk about accident at work and gym. So we will educate or bring to your attention what you need to do when you confront or encounter any accident or injuries at work or in gym or leisure places. So it's very educative because a lot of people have been, let's say, victimized, or they've been in that situation without not knowing what to do. So, Legal Hour is to obviously educate ourselves, the African community, about what we need to do, our rights, and of course, our main sponsor, City Law Solicitors, they've been our backbone from day one. Tonight, I'll be here with my usual guest, lawyer Thomas Beyebenwo, and we will be talking about, a lawyer will be explaining and obviously giving more information and update on what you need to do when you are confronted with any challenges regarding accident at work, at gym, and I've got a lot of questions to pose to lawyer. Later on, I'll open the phone lines, and I will definitely acknowledge my viewers as well. I will entreat everyone to call and ask questions. We'll give you the opportunity to also call and ask questions not related or specifically directed to the topic, but then it could be any aspect of law or anything that probably might be baffling your mind. So we are here from now till maybe the next hour. That is it for now. I'll be introducing lawyer very soon to the program. I will entreat you to share this program for all your viewers, your friends and your family to benefit from this as well. Most especially those who are in the UK, because the law that obviously we talk about is in relation to the UK policies and then the legal framework of UK. So I entreat everyone to share. Thank you very much, and I hope you stay tuned, and then I'll see you briefly and introduce lawyer to you. Thank you. Stay tuned. Don't go away. back, viewers. So as I said earlier, tonight we're going to talk about accident at work and at the gym places. So a lot of people have been victimized. They've been to work where they've been injured, and obviously they were unable to make any claims. It's very pathetic when a lot of people experience or encounter such issues without not knowing what to do. And of course at recreational places as well, such as the gym. So we've taken it upon ourselves to discuss this topic. It's very relevant, and it will go a long way to help a lot of people. So yeah, I'll be introducing lawyer briefly, but then obviously I'm proud to say that this program is sponsored by City Law Solicitors. They've been our backbone from day one. And then also you can listen or enjoy this program on City Media Radio. City Media Radio, you can access this on Modern Ghana platform. If you go to the abroad section, you can click the link, City Media. I've shared it to all my contacts. Lawyer has done it. So please make sure you share this program for others to benefit from that. Also, this program is live on Facebook and of course on YouTube. The name is Solicitor Thomas Beyebenwo, and you'll be able to get this program. So yeah, I'm switching to Thomas, obviously lawyer, and then I'll be welcoming lawyer in a minute. But please make sure you share, and I'll acknowledge my Facebook viewers. So if you are watching this program, make sure you give me a thumbs up. You let me know that obviously you are watching the program, and I will be able to know that you are still with us. So give me about a minute. I'll be back, and obviously I'll introduce lawyer. Please stay tuned. Don't go away. A bit of technical hitches. Please bear with me. I'll be back. Don't go away. I've got lawyer in the studio. Good evening, lawyer.
Good evening, everyone.
Welcome to the show. You're looking very smart as usual.
Thank you.
I know you've had cold today, but obviously you probably need to speak up for viewers and listeners to exactly hear you.
Yes, I'm feeling a little bit under the weather, but I will try to provide my voice.
It's everywhere. I think it's the change of weather, isn't it?
I think so. I think so.
But I'm sure this is not COVID.
No. I'm very strong immune system.
Now we know the difference between the cold and the COVID. Yeah, obviously.
Do we really know the difference because they have similar symptoms?
I think the COVID is a bit more to do with the chest, the coughing bit, and sometimes you feel it inside you, isn't it? Have you had COVID before? I honestly had it when it first came. By the way, when it first came, I'm part of the early, So. Yeah, I had it. So, lawyer, interesting topic tonight. We're going to talk about accident at work, and obviously the gym as well, and our right and to make claims. This is very, interesting. So, the question is that a lot of people have been, let's say, victimized, or they've had issues with work. In terms of accident or whatever. So, which people are eligible for? Personal injury claims at work, especially when they are confronted with such issues. Which people? Which category of people?
Yes. obviously people have right to claim compensation when such accidents occur at various places. But tonight we are focusing on accident at work or accident at the gym or these recreational centers. So obviously, employees who are employed by the employer, when there is an accident that it was not their fault, then obviously they are entitled to claim compensation. But most time people just take sick pay and then they ignore the fact that that accident might have caused them some injuries that can be long-lasting, some can even be permanent disability. So if I should answer your question, employees are entitled, but obviously even self-employed people who are on the premises will soon see that under the occupier's liability, people have various ways of making such claims.
All right, thank you very much. You've mentioned the occupier's liability thing. So I want you to go into the legislation that underpins all these personal injury claims, especially at work. Can you throw some light into the legislation that underpins that?
Yes. Obviously, everybody knows. That's why we do most of these programs. So everybody knows that in the UK, the law is always changing. It's just like the weather. Tomorrow is a rainfall, another time it's either winter with snow or sunshine in summer. So every day the law is changing. Now, initially, people could make these claims under the common law or statutory law. When I say statutory, it's legislation such as Health and Safety Act 1974. Initially, people could make claims, but up until 1st of October 2020, there was this act that was introduced by David Cameron, the Conservative then Prime Minister, which is called the Enterprise Reform Regulatory Act. That removed the line on statutory breach, which is breach for health and safety and all those stuff, to make a claim. So currently, as we speak, people have right to claim compensation when accidents occur under the common law.
All right. So my next question is that the employers actually, in what ways are they liable for accident at work? If you can obviously throw some light into that, in what ways are employers liable for accident at work?
Yes, they are liable because they owe a duty of care to those employees on their premises. And as we go through this, we understand why employees, including those who are visitors and all that, will be entitled to claims when accident, because those employers owe them duty of care whenever they are at work or whenever they are performing duties in the course of their employment.
All right, talking about duty of care, that is a very interesting point to hint on. And if I may ask you, what duties have they got, obviously, towards their employees? Let's tackle the employers. Their employees first, the duty of care towards employees, and I'll come back to another duty of care to other people that comes into the premises. So focus now on the duty of care towards employees.
Yes. Employers, as I was discussing Tuesday in the Tree version, have various duties to their employees whilst they are on duty or they are at the workplace. And normally, under the law, we divide it into about 4 sections. They have a duty to ensure that they provide safe premises for the employees to perform their duties. What I mean by safe premises is to ensure that the premises is safe, that things not lying around that can cause an accident. not cables that can keep short, electrocute staff whilst they're on duty. And they also have a duty to provide sufficient machinery and plant. So what I mean by this is that, for example, if you work at Tasco, then your employer needs to provide you those tools that will enable you to do your work. So obviously they will have to provide stuff like cage that are effective and movable. So if they turn out to be immobilized and you end up pushing it and then you trace your waist or you sustain injury in your waist, then of course they have not been able to provide that sufficient plant and machinery. So there are all these sorts of ways that employers need to do to ensure that whilst these employees are on duty, they are able to perform their duties sufficiently without having to incur some injuries.
Okay, thank you very much. So the focus is still on employees and then the duty of care that employers need to have towards whatever they need to provide or making provision for whatever they need for their job. Does it need to be contractual? Does it need to form part of a contract that obviously employers give to employees to sign?
Yes, as we go along, we'll notice that contract, both under the Contract Terms Act and then under the Consumer Rights Act, which I'll go into detail in due course. Mm-hmm. Things such as death or personal injury cannot be excluded. Even if they are excluded, employers cannot rely on them to avoid liability of compensation. So even if they put it in their contract that they are not responsible for whatever happens to you and all that, there are various ways that you can make your claim, either under the occupier's liability or under the common law duty, where they have a duty. For example, I mentioned two of them. Some of them could also involve providing the person with equipments. Some people, they are scaffolders, they need a ladder to be able to climb. Some have.
All right. So whilst lawyer is paused, because obviously lawyer is not feeling much better today. He's got cold. So before you continue, let me acknowledge my viewers, especially on Facebook. I know Mr. Leboko, Atiko Leboko, is listening live. He just sent me a message that, Chaka, I'm with you guys all the way in Belgium with his family. Big up to you, Atiko Leboko. So we've got Abna Kwachiwa on Facebook. Abna says, you are welcome, lawyer. Entry Tano Sapon, amount for senior Big Stone is watching. Patrick Yaboa in Ghana says, boss, you are the best. Thank you very much, Patrick. Thank you. Okay, Tiga Upa Edwards. Tiga said, good one, bro. Kofi Boateng Zilla, my own Akonta is watching. Kofi Boateng, thank you very much, Akonta, all the way in Ghana. Ernestina Kakari, thank you. Samuel Ganza, wow, Genero. Samuel says, nice one, guys. Thank you very much, Genero. And thank you very much, brother, for hosting me when I came to Birmingham. It was really good. You were very helpful. Thank you and your family. I really appreciate your help. Thank you. Genero. All right. So, Obaya Pokia says, good evening to you all. Good evening, Obaya. Good evening, Mami Yu. Mami, thank you very much. Mami Yu is always with us. Thank you for watching, and make sure you share for your contacts to enjoy as well. Kofi Boateng says, watching you live, Akonta. Keep up the good work. Thank you, Akonta, for your motivation. Desmond Beniana, thanks for good job, lawyer. And Chaka, God bless you guys. Thank you very much, Desmond. Nana Freeman says, good evening, MC Chaka and lawyer Thomas. And then Ernestina Kakari says, good work. Thank you very much. You know what? If we get all these messages, that gives us the motivation. So please make sure that if you are here with us on Facebook, drop some comments, and then obviously I will read it out to acknowledge you, and then that will keep the program very lively. And make sure you share as well. And for those of you who are listening to the program from the radio, please, you can send me a message or you can drop a message to let me know that you're with us, and I'll be able to mention your name on the radio. So this program is live on radio and on YouTube and Facebook as well. So thank you very much. Back to the questions, lawyer. So lawyer, what course of action do employers need to prove that, we're talking about employees rather, what course of action do they need to hold employers liable for accident at work? That is a very deep question. I mean, they need some sort of course of action, but what course of action is that?
Yes, it's very important that I take my time to explain this, because this forms the crust of this whole topic. So I'm going to explain this in stages and in a very layman's language, so that viewers and listeners can understand, so that they don't forfeit those rights when they have these injuries at the workplace. Now, the course of action they need to prove is that of negligence. So, in a way in which they can prove that negligence is that I've already set out that employers owe a duty of care to the employees. And that duty of care, I've also set out that it involves providing machinery and plants, equipment, competent staff, safe premises. So I'm going to explain each and every one of these ones. So let's say, for example, the employee working on the premises with another employee, and obviously that employee, whether they are related or whatever, out of the fact that he's doing his work or he didn't do his work properly, maybe he was pushing the cage and then you push another person. That person fell down and then had injury. The mere fact that that accident has occurred, which has been caused by a fellow employee, makes the employer vicariously liable for that injury. So the way in which we'll be looking at it is that that particular employee is probably not competent, because the employers have a duty to employ competent staff, and those staffs are to be competent to the extent that they will not cause unnecessary injury to their fellow employees. You know, when you are driving, you don't know how to drive, you're more likely to cause accident on the road. Yeah. So the same applies here. It's a common law duty. Yeah. They are also there to provide machinery and plants. As I've just said, they have to make sure that if the person needs a ladder, they provide that ladder. They need to provide equipment. You go to some of the cleaning sites, they don't have gloves, they don't have buckets, they don't have certain things that they need to use to be able to do their work efficiently. If, as a result of not having gloves, maybe they put their hands in the chemicals and then they sustain some injuries, that means that that employer has breached that duty. Safe premises, if you're a carer, you go to the premise, you go ahead and do some work. The employer is supposed to do risk assessment to ensure that that premises is safe throughout the period that you'll be there to be doing your work. If you are a contractor, if you have been sent out to go and do your work in another place, to the extent that you are performing this in the course of your employment, then that employer owes you that duty. Now, so once we have established that a duty is owed, if that duty is breached and that accident is caused by that breach, then that particular injured employee has proven his case to claim compensation from the employer.
All right, thank you, lawyer. So what about, let's say, if the accident is as a result of the employee's negligence? For instance, the employer has provided gloves, the ladder is there, and the employee is sort of using a shortcut or maybe other alternatives to do the work, and in the course of that sustains an injury, can the employee still be liable for any compensation or claim?
Yes. Normally, when claims are made against these employers, they also have recourse to defense. So sometimes the defense could be contributory negligence, where, for example, that particular employee has contributed to some extent to his own injuries. So, of course, if the employee has willingly caused that accident to himself and has sustained injuries, then the employer will not be liable for his injuries, and to the extent that he will be liable for compensation. So that's why I set out that they need to prove what they call negligence, and that negligence is proven when that duty of care is breached. So when duty of care is breached, then it means that that employer has been negligent. So you say, for example, they didn't do proper risk assessment, and then the other person was working on that premises and sustained injuries because the premises were not safe. It means that that employer has been negligent. So under those circumstances, the employee will be entitled to compensation on the basis that that employer is liable for his injuries, his or her injuries.
All right, thank you very much. Let me acknowledge 3 people because I think the number is going very high, and I need to appreciate and of course acknowledge my viewers. You make this program very insightful, very interesting as well, because you draw your comments, you obviously share the program for others to benefit, and that is how we're going to go far with the program. DJ Ricky is a presenter as well as Source Radio. Ricky, thank you very much. I've seen your message that obviously you are watching, and you sharing as well. Kwame Fitali is listening to the program all the way in Italy. Paul Amanfo is watching. Amanfo, thank you very much. Auntie Sandia has given me thumbs up that she's with us. Majua, Majua, how are you? I know you're doing well. Majua is here. Sister Amma, AAA. Sister Amma is with us. Sister Amma is the host of Wuntime, what do you call it? Apumding program at Wuntime Radio in Ghana. Thank you very much. Nana Kwame is here with that. Nana Kwame says, nice one, bro. Thank you very much, Capito. Nana Kwame. Thank you. I hope the family and everyone is doing well. Augustine is here with us. Righteous Ghana. Righteous is here. Ajakuma has given me thumbs up. Pamela K. Yeah, Pamela has given me a thumbs up. Belinda is also here with us. And then, of course, I've got Lydia B. Osu. Good evening, Chaka and Lawyer. Good evening, Lydia. Thank you very much for watching. Nana Usu, I'm watching the program live from Eastham. Nana Usu, thank you very much. Kwame Ansa, well done, Lawyer, and God bless you. God bless you too, Kwame Ansa. God bless you. Desmond Benia is watching. Nana Frima is with us. Thank you very much, our viewers and our listeners as well. The program is live. We bring to you every Tuesday and Thursdays. We're doing the English version today. Usually it's on Tuesdays, but we've obviously swapped, and now it could be either way. So please, when you get the update, make sure you join us and enjoy the program, whether Tree or English. So, Lawyer, we're going to talk about the compensation, because people sometimes get confused. They don't know how much they're eligible or how much they'll be entitled for. You know what I mean? So, what are the potential compensation that employees can claim as a result of accident at work? Is it a lot of money? I mean, can they reject it? Please educate us on that. Thank you.
Yes. The main reason I'm doing this is that in the course of our practice, we come across clients who are being bullied. Some of them have genuinely sustained accident injuries. They had accident at the workplace. They sustained injuries. They went to either A&E or they went to the hospital or their GP. they had treatment, and then they go on sick leave. And the most annoying part of it is that these employers keep chasing them, writing them letters, threatening them that, for example, when they have been off for about 2 weeks or more, if they don't return to work, they will be sacked. Merely because some of these people are just claiming company sick pay. So I want to make this distinction here. When somebody had had an accident at the workplace, that entitlement is not limited to the company sick pay, or for those who don't have company sick pay, because company sick pay is not enshrined in every employer's contract. Some employers don't even give company sick pay at all. So those ones, some people will be on what they call statutory sick pay. So coming back to the crust of the elements of the compensation, when people have sustained these accidents at the workplace and they have solely, they've been able to prove that the employer is responsible for their injuries by reason of being negligent, then they are entitled to compensation. And these are the elements of the compensation. They are entitled to compensation for any financial loss. That's one element. So let's say, for example, those who don't have company sick pay, it doesn't matter how long they've been off work. If they are off work for about 6 months, that means they have lost some finance, some funds. Some people may be doing 2 jobs. They will end up not be able to do their second job. It means they have lost not just their source of income from the employer who caused their injuries, but the income from their second job. So this loss of earnings can be claimed. The second element is all costs incidental to the accident. For example, going to the hospital, taking a cab. Some people, for example, because I'm under the weather, I went to the pharmacist, I paid for my medication. Some people pay for their own medication. So when they pay for all this medication and all the incidental costs associated with this accident, they are eligible to claim it. In fact, even if for example, it was when cars that their clothes got damaged, they can claim for it. And then going beyond that, they don't need to stress themselves, because they can also get paid. They can get a carer who will look after them, clean their house, accompany them to the GP. And all those, so if you are, and the good thing is under the law, even if it's your daughter or son who is taking care of you, that person will be paid for the number of hours that she's been performing those duties. And most important of it all is the injury itself. So if the injury occurred on your face, and you are not married, maybe you are a young handsome man or a young beautiful woman who is yet to marry, and then you got accident at the workplace, you are disfigured, your face, there is a mark there, indelible mark. It means that this is going to diminish your chances in life. So it means that you will be entitled to huge compensation. Some people may have fracture that will lead to permanent disability. So the injury itself will also be assessed, and people will be entitled to huge compensation depending on the severity of the injury. So these are the elements of compensation that people are entitled to when they sustain these injuries at the workplace.
Okay, thank you very much, lawyer. Lawyer, another quick question I want to throw. So let's say, because I've worked as a security with a security firm in the past. And there are some procedures that obviously should be in place. I'm not sure. I think, and then obviously, as lawyer, you'll be aware of this. It's called RIDDLE, and the meaning is that to report of injuries, disease, and dangerous occurrences regulations. Okay, so as part of that, every incident or every accident at work needs to be recorded in the accident book.
Yes.
And that will be an evidence, or sort of, it will, in terms of compensation claims, or if anybody wants to claim a compensation against the company. But then what will happen if you've had an accident at work and you've not followed this procedure? Obviously, by making sure that it's recorded in the accident book to evidence your accidents, or if you want to claim for something, what actually happened? Can there be any entitlement if you make a claim for compensation?
I'm very happy you asked a question, such a sensible question like this. I personally got involved with somebody that we were doing a claim for. He had an injury on the shop floor as an employee at Tesco. That's about from a couple of years back.
Yeah.
We pursued the claim, we got the medical evidence, everything was ready. And then the employer denied that there was ever an accident. And the challenge was that none of the employees that was there was willing to testify. So this riddle that you have just raised is very, very important, that when people get injured at the workplace, they should ensure that they write their incident reports. They should ensure that it's recorded in the company's accident book. Because if they don't assist in producing or in creating those evidence, then when their case is being pursued on their behalf, the employer can simply deny that there was ever an accident. And in fact, that is why the government put this regulatory system in place, the riddle, that these accidents can be reported whenever. It's not all accidents that people, I must point out here, it's not accidents that people will be eligible for compensation. Some could be minor accidents that, as I've said, might not even cause you any injury. But all accidents need to be reported. But most importantly, if those accidents are not recorded, then the employer may deny that there was ever an accident. So people should take note of that.
Okay then. The next question is that what are the potential defense an employer can obviously based on to deny or to appeal against a claim for compensation? Are there any potential defense mechanisms or factors that they can rely on?
Yes, as I set out, I already said that before one can be successful in making a claim against the employer, they must first establish that they are owed a duty of care, and that duty was breached because of the employer's act. And those acts could be either because there was incompetent staff who have caused the injury to a fellow employee, insufficient tools or machinery, lack of safe premises. So for one to make successful claim, that person needs to establish that either of these has occurred. So employers may have a defense if employees cannot prove that. Most times, once you're at a workplace, you already owe the duty of care. But if you cannot prove that that duty was breached along these areas, then it becomes very difficult. That becomes a defense. So the employer will say, yes, I owe you a duty of care. I didn't put staff around. Maybe you were running around and then you fell. So I didn't cause your injuries. It's not because of the fact that I breached that duty, but it was sometimes through your own fault.
Your negligence.
Yes. So if that negligence is not proven, but most importantly, sometimes employers also rely on what they call contributory negligence, where people go beyond certain things that they are meant to do at the workplace, and then they also cause themselves some injuries. So in fact, defenses could be contributory negligence or no duty of care was breached at all. So those are the defenses that employers can put across. And that's why people need to make sure that these accidents are recorded in the accident book, because if it's not recorded, they can say that there was no breach.
All right, thank you very much, Leah. Let me continue to acknowledge a few people that have joined the Facebook. I'm very impressed the way people coming out with comments and being part of the program. So Lydia is here with us. Nana Owusu, I'm watching the program live from Islam. Kofi Ansa says, well done. Mary Akusa. Oh, Mary. Yes, Mrs. Leboko, Atakre's wife, Mary. Thank you very much, Mary. Mary is watching all the way from Brussels. Thank you very much. I hope my children are doing very well. Thank you very much, Mary. Yeah, so Fred Chadanso is watching. Says great program. All right. Mrs. White says, lawyer Thomas is full of wisdom. Yes, of course he is. So Fred says he could hear some feedback. We should check it. All right. Thank you very much, Fred. Pastor Fred Chida, so Pastor Amanfo. Thank you very much, Pastor. We check the feedback and we will resolve it. Thank you very much. Sana says very useful information. Thank you, sir. And then Mary is back again saying very great, watching from Brussels and Leboko. Thank you very much, viewers, and obviously listeners as well. So we are here every Tuesday and Thursdays, and now we're doing the English version. Lawyer has already covered the Tree version. So next week we'll bring you another educative and insightful topic. But then I've still got more questions for Lawyer. And viewers, if you have any question at all in relation to the topic or anything outside the topic, you can still put it on the comment. I'll give the opportunity for people to call the studio line. I'll put it online. But then please make sure you throw comments if you've got any question at all. As we go, I'll make sure I read it, and then Lawyer will be able to answer your questions. Lawyer, is there any particular time frame that obviously this needs to be claimed? For instance, the accident or the injury happened, let's say 3 months, and I've not done anything yet. Is there any time frame that obviously you can file for compensation?
Yes. The good news is that people can entitled to make claims within 3 years. So they have good 3 years. So under the Limitation Act 1980, personal injury claims can be made within 3 years. If it's beyond 3 years, then you have to give very good reason why you didn't do it within 3 years. So the limitation period is 3 years. So if any of you watching us tonight or listening to us tonight have had an accident within 3 years, that you think that you didn't make a claim, you are still entitled to make a claim because the limitation period is for 3 years.
All right, thank you very much, Lawyer. Now let me come back on visitors. You know, you've spoken about employees. Now visitors, people that have visited the premises, they've come to see someone, or they've come, let's say, to the shop, or they've come to do something else rather than working for the company, and as a result of that maybe slipped and they get injured. Is there any requirement or any regulation for them to get compensation for their injuries?
Yes, visitors are also entitled to make compensation when they sustain injuries, even though they are not employees. And the legal framework or the grounds is the Occupiers Liability Act 1957, which provides that the premises should be safe for licensee or visitors. So any visitor who has come to the premises and for one reason or the other has sustained injuries because the premises were not safe, then even if they are not employees, they are equally entitled to compensation, provided their injuries was caused by the negligence of the employer.
Thank you very much, Lawyer. We're going to go for a very short commercial break. When we come back, I will definitely have some more questions for Lawyer, and then I'll open the phone lines for viewers and listeners to call the studio line. I'll put the studio line there. We're going to go for a quick commercial break. So when I come back, then obviously we will talk about a couple of questions that I've got for you. In addition to what I've already asked, we'll do some follow-up questions, and then I'll open the phone lines for viewers and listeners to obviously come up with questions. So please stay tuned. Just a minute, we'll be back. Commercial break. Well, having some technical issues. So, yeah, Lawyer, I hope you're doing well, because I wanted to give you the time to drink some water. But you're okay. Yeah, that's fine. So, Lawyer, if anyone wants to make a claim, is it advisable for them to do it by themselves, or would you recommend that they contact a legal practitioner to represent them? I know this is the time for you to sell yourself, so please do it and let's know if it's advisable for them to do it on their own or they need someone to represent them.
This is what they call conflict of interest, because if you ask me that they need to do it themselves, then why am I in business? Yes, but very interesting. The point is that as lawyers, our duty, we owe a duty to our clients, and that duty is to protect their interests. So the difference we can make to the matter is to maximize the compensation for the clients. And the good thing is that most of these stuff is what they call one-way cost shifting. So if you do it under conditional fee agreement, you don't pay anything if you lose the case. If you win the case, then you pay a little bit of percentage to the lawyer. And then the legal cost is paid by the loser. So there is absolutely no point for people to do these claims on their own, because one, there is no pecuniary benefit for doing it your own, and second, because you might not be able to maximize the compensation on your own because of lack of knowledge, because obviously there is way of assessing these claims, and medical experts are involved. There are various ways of going about it and all that. So it's always advisable that people should consult lawyers. And I'm sure that a lot of them.
Okay, so I mean, should anybody consult you? Do you do it on a no-win basis?
We do all our
no-win, no pay.
All our personal injury and clinical negligence cases on no-win, no pay.
Okay.
So you don't, the conditional fee agreement, you don't pay a person towards the case.
All right. So let me sell you a bit then. So viewers, if you encounter any issues, any accident at work or anywhere, or if let's say you become a victim to this, you know where to go. So Thomas, or lawyer Beyebenwo, is he's a solicitor, and he's got colleagues obviously that they can help you in all aspects of law, everything that you want to do, whether it's immigration, employment, they do family law, personal injuries and clinical negligence. So if you've been to the hospital and they meant to fix your eye, and later you realize that one of your eyeball can only see the backside, then you'll be eligible for something because they've not been able to do what they meant to do. Commercial disputes and civil litigations, they do housing law, consumer law, and then media law for those of you that are in entertainment that want to do a lot of things. So there's more that they can do. So what you need to do is to contact them. Their office number is 0203 355 0782. The number once again is 0203 355 0782. The reason why I'm not giving you lawyers personal number is you can imagine how busy he is. Sometimes he might be in court, he might be attending to other things. So when you call the office, his learned colleagues will be there. Equally, they are very good. They'll be able to take your query, they'll give you advice, they'll give you directions to the office, and you'll be sorted out. So please make sure that you contact the number. They are located at Unit 113, Backen Enterprise Center, 50 Cambridge Road, Backen, XS, and the postcode is IG118FG. I repeat, the postcode is IG118FG. So please make sure that you don't look anywhere further. Contact them, and of course they will be able to sort your legal matters and everything for you. City Law Solicitors is building a community, an extensive community that will support everyone, especially the African community. So please make sure that you channel all your legal matters to them, and they will help you. And I mean, last time a lady called and testified that they don't charge much, but then he's got a passion for you to win your case more than even the monetary aspect. You see, and I've known Thomas for a very long time. We've come all the way back from the University of Ghana, and he just, I I don't even know what word to use to describe him, but he's down to earth, and of course he's humanitarian. I mean, he enjoys seeing people being successful and obviously achieving a very good outcome of whatever he does. So I mean, just satisfaction is his ultimate goal. So please make sure that you contact them, and all your legal matters will be sorted out. Lawyer, are you happy for us to continue?
Yes.
Okay, that's good. Yeah. So, can employer sack employee if they make claim for compensation or personal injuries? Can they be sacked as a result of that? Because a lot of people are scared to report or to claim because they know after that their job will be gone. Can that be possible, please?
Yes. This is why a lot of my fellow African brothers and sisters are terrified to come out to make claims for their injuries. And I have it's not just work. Sometimes some people feel that maybe because of immigration problem, they cannot even claim for compensation when they get injuries. And last time I shared it with viewers where one of my clients, after going through his immigration stuff and regularizing his stay, he confided in me that he had an accident about 5 years ago. He was called to pursue the claim, but he ran away because he didn't want to get involved because of his immigration status. So it's not about immigration status. It's about the fact that you've had injuries, and most of these claims settle out of court. So people should not be terrified to come forward, even if they have issues with their immigration status. Because I have personally been involved with people who have those issues, and they could say make claims. But coming back to the actual question, which is, can employer dismiss employee for making a claim for compensation for their injuries? The answer is no. Under the Employment Rights Act 1996, Section 98, that clearly will be an unfair dismissal. But the point here is that for one to be able to claim unfair dismissal, that person should have been employed for more than 2 years under the law. But for those who have not been employed for more than 2 years, it doesn't mean that they don't have grounds for making a claim. They could also pursue the employer in a civil court for breach of contract. So there's absolutely no reason for people not to come forward and claim compensation for their injuries when they get injury at the workplace. Because normally, what we have learned is that when those injuries occur and then lawyers are involved, those employers are even terrified to go near that person. They will not even make any effort to even attempt to dismiss that person. And sometimes when they are threatening staff members who have had injuries and they are on sick leave, once lawyers write to them, they just stop. Because they know that a lawyer's duty is to help you to maximize your right and to get the compensation that you deserve. So I'm advising people, if for whatever reason they are scared that they may lose their job by coming forward, they shouldn't be scared, because rather they will be protected by their lawyers and they will continue to enjoy their work even better after they have made those compensation claims, because those employers will not dare come near them, because they know that if they come near them, those lawyers will pursue them for unfair dismissal or breach of contract in the civil court. So they have this right to pursue these claims.
All right. The reason why I asked you this question, because I know someone, and it was really sad when she injured herself at work, and for some reasons she didn't make any compensation claim, but then it affected her ability to work effectively with the company. So when she as a cleaner, when she could clean maybe 5 floors, it was limited to maybe 3, and she was not carrying heavy stuff, you know what I mean? And long story short, what they did was that when there was a time for them to put people forward for redundancy. She was the first person to be selected.
Yeah.
Even though she didn't make a claim, the injury affected her ability to work effectively or to carry her normal duties, which doctor's note was in place. Yeah. So legally, she was mandated to do that hours or not to lift heavy stuff. Yeah. But then when there was time for redundancy, she was selected for redundancy. Can that be termed as unfair or constructive dismissal?
Yes, this is a very technical question. Remember that there are two distinct areas of law here. There is one to do with the fact that if your injuries have been caused by the negligence of the employee or an employer at the workplace, then you are entitled to compensation for your injuries if you so wish to pursue it. But if you decide not to pursue your personal injury claim, and then allow the employer to just go scot-free. When it comes to issues of redundancy and all those stuff, remember they do scaling. So you could actually be fairly dismissed on incapacity grounds.
Okay.
I have an employee, I have a client that I'm dealing with now. He is smart. He's made his case, he's claimed the personal injury, and he said that they initially wanted to make him redundant, but now they've even put him on pay for some time because the amount, when he bought a settlement agreement for me to sign, the amount of money they were meant to give him was not enough. So when I wrote to them, they just back off. Sometimes I get frustrated that people don't seek legal advice. Yeah. So that some of these things can be corrected. So quite rightly so, they can make that person redundant because the issue of making you redundant has nothing to do with your personal injury right. It's to do with whether or not you are capable of doing the work. And if they are doing the assessment and they feel that there are other people who are more capable to do the work more than you, then perhaps they can say that based on the scaling, you are first to go than the other person who is more capable. Okay,
thank you very much. I'm quite conscious with time because I intend to finish the program within an hour. So let me ask you about gym as well. A lot of people have registered to gym and other recreational centers. I'm not sure of the contracts that they signed, but then when it comes to personal injuries and compensation, what sort of benefit or what compensation can they get if they injure themselves at gym or at other recreational centers?
Yes, thank you for the gym question. This is a very good question. You know, I also enjoy the gym, my
yeah, of course, yeah.
As a fitness trainer,
yeah. Jack of all trades.
I'm a fitness trainer. If anybody wants that service,
very good with massage. And
no, that's a separate title. This one is that is fitness trainer.
Okay, but massage comes with that, isn't it?
No, that's a separate course I did.
Oh, is it?
That's not
okay. Is it Thomas is very proficient in all areas.
So let me talk about the gym.
Go on, please.
Now, remember we discussed Consumer Rights Act. We've been having a lot of discussion. When you look at the Consumer Rights Act 2015, Section 65, it says that a trader, by the term of consumer contract, cannot restrict or exclude liability for death or personal injury claim. So if you have signed a contract with your gym provider and he said that, when you come to the premises, if you get injured, he's not liable. I am telling you today that is a breach of the Consumer Rights Act. That is the first recourse to your claim, breach of contract. The second breach is that under the Occupiers Liability Act 1957, I enjoy it because it cuts across, even when we did the housing disrepair. That was very, very, very helpful. So under the Occupiers Liability Act 1957, when you go to that gym premises, that provider has a duty to ensure that you'll be safe throughout the period that you are there for your exercise. So if the machinery, if for example you're on a treadmill and it suddenly stops and then you get injured, or they are supposed to provide competent staff. I know that with respect to most of them, a lot of people are in the gym. They don't even have this qualification, the fitness trainer,
the PT
qualification. Yes, they don't have the
personal fitness trainer
certificate because it's an unregulated area. So a whole lot of stuff. Last time around our place in Backing, somebody fainted.
Wow.
Now, with my experience as a fitness trainer, whenever somebody comes to the gym, you are supposed to do assessment, even sometimes get medical report to ensure that that person is put on certain course but cannot sustain injuries. So if those staff are not able to do all those things for their customers, and one reason or the other they get injured, then they are also entitled to compensation. End of this story.
All right, thank you very much. So, are they able to exclude personal injuries liability in terms of the contract? I mean, talking about personal injury claims with the gyms and recreational centers. Can you do that?
I just combined it with when I was just explaining. That's why I said that under the Consumer Rights Act, 2015 section 65, it makes it clear that a trader cannot by consumer contract or term exclude liability for negligence, for debt, or personal injury claims.
Okay.
So it means that they are not entitled to exclude it. So if they exclude it, it's a breach of contract.
Okay.
And also, if they don't put notices there for things that are defective, it's also equally a breach of contract.
All right.
And therefore, those people should be entitled to compensation for their injuries.
Okay, so viewers and listeners, it's time for you to call the studio to obviously throw questions. The number to call is 079 32 93 4518. I repeat, it's 079 32 93 4518. The other number is 074 40 33 8623. I repeat, 074 40 33 8623. So when you look at the bottom of the screen, you see the studio numbers there as well. You can call the studio now, ask lawyer any question you could relate to this topic or any other aspect of law that they cover. And lawyer is here. He's very knowledgeable. He's very equipped. He'll be able to answer all your legal matters for you. So please do so. We're here waiting for your calls. Make sure you be part of this program. Or equally, you can drop a comment. If you are not obviously ready to call, then I'll be able to read it for you as well. Let me acknowledge three people that are watching us. My sister Anita Mamiesi is watching us. Mamiesi. So Mamiesi is a discount shopper. What she does is wherever you are in the world, Mami can shop for you. I mean, on a very affordable prices, and then we'll ship it to you wherever you are. So, and then also she is an Avon VIP group member. So if you need anything of that sort, Avon products, or if you need someone to do your shopping for you, whether in Ghana. When I went to Ghana, she had done a lot of shopping for people in offices, and I was impressed with the prices that came with it. So if you need to contact Mami, the email is thediscountshopper@gmail.com. thediscountshopper@gmail.com. Please contact her. Her WhatsApp number is 079 600 22058. She's my sister, so I need to promote her business. So please make sure you contact Mame. If you need me to promote your business, please send me a message and then we talk at back door, please. Yeah, so this is my sister and I have to promote her business. And she's watching us live and she shares this program every time we come live. So thank you very much, all the way in Northampton. Thank you very much, Mame, for sharing the program for us all the time. So phone lines are still open. Please make sure you call the line, the studio line, And the lawyer will be here to answer all your questions. Phone lines are open. Let me acknowledge a few people that are here too. So I'm sorry if I don't pronounce your name well. Kwastopo says, Lawyer Thomas is very proficient in what he does. The time I spent working with him on my legal issues, he proved very knowledgeable and high level of professionalism, and my issue was 100% sorted. I highly recommend you contact him if you have any legal issues that needs instant advice and solutions. This is a message from one of your clients, Kwastopo. I don't know if are you familiar with the name?
Well, so some people have.
Yeah. So I mean, I'm really touched with this testimony.
That's nice. Good to hear.
Fred Asari says, good evening, boss. Edmund Kwao is watching. Thank you very much, Mr. Kwao, for watching. Daniel Amanfo Kwabna. Daniel says, great apostles, well done. Now we are both apostles. Remember last time it was Apostle Chaka? Yeah. No, I think we deserve the title apostle, isn't it?
Yeah. Because we are spreading the good news.
Exactly. Thank you. I mean, I tap into that. Yeah, I tap into that. So Daniel Amanfo Kwabna, in fact, very good program. Thank you, my brother. Thank you. So yeah, phone lines are still open. Please drop your comments, and it shouldn't just relate to this topic, but in any aspect of law that they practice, and they'll be able to sort you out. Mr. Leboko and his wife Mary, they watching us all the way in Belgium, Brussels. Big shout out to you, Atiku, and your wife Mary. Thank you very much. My regards to everyone. Miss Yabot, and then Kenkwashi. My regards to all of you. Thank you very much for watching. And then I'm Senior Big Stone, watching from Holland. Big Stone, thank you very much. You always listen to the radio. You love saying music. You and your wife, Big Stone. Wow, I'm on for. And then Senior Doggy, I'm on for. Do you know Doggy?
Yes.
Yeah, Doggy shares the program all the time to the Amount 4 platform. Heathrow. Yeah, that's right. Thank you very much, Senior Doggy. I mean, I really appreciate you sharing the program to the platform, and I see that all the time. And this is what we want people to do. We spread the good news, so we want it to go far to reach a lot of people. We've received a lot of recommendation for the program. So please call. If not, then I'm going to give Lawyer 2 minutes to wrap up, and then I'll bring the program to an end. So Lawyer, whilst we wait for people to call the studio lines, and please note that the number is at the base or the bottom of the screen, so call and then pose any question of your choice to Lawyer. Lawyer, please wrap up in less than 2 minutes, please. Thank you.
Yes, I will. Thank you everyone who has been watching us tonight, including those who watch us later after we have left the studio, both on YouTube and Facebook, and our City Law Solicitors fans who are also listening to the City Media Radio. This radio is for you to listen to this legal hour and also to enjoy music. With, DJ Chaka is always on there. Yes, coming back to the law, tonight we'll discuss accident at the workplace, accident at the gym. In fact, we'll be doing many of these programs so that people can know their right to claim personal injury when they get accidents, various places, public places and all that. We'll be doing most of this. So continue to follow us and you will not be disappointed. So tonight, we have basically discussed that if you are an employee and you are performing your duties as an employee, then you are owed a duty of care by your employer. And that duty of care includes providing safe premises for your work. They have to do risk assessment to ensure that whenever you're doing the work, you are safe. There will not be unnecessary accidents there. They have to also provide plans and machinery. So if you're a scaffolder, you must have ladder. They have to also provide equipments. Obviously, if you're a cleaner, you need the gloves and all those stuff that makes your job quite easy or efficient. And then they also need to provide competent staff, which means that if Kujo and Ama were working at the same site, and Ama caused injury to Kujo, or Kujo caused injury to Ama, even if they are known to each other as friends or family, the employer is vicariously liable for the injury of the person who has sustained injury in the hands of the other work colleague. So, under the law, they are meant to provide what they call competent staff that will not do their work in a way that will cause injury to other employees. So if any of these duties is breached and someone sustains injuries, and those injuries are not so remote, which is something that is foreseeable by the employer, that by those actions, those injuries can occur, then they will be entitled to what they call compensation, because there has been a breach of those duties. And that compensation includes your financial loss, it includes your medical expenses and somebody who looks after you, and also includes the injury itself. And I said that depending on the nature of the injury, if your face is disfigured or if you have permanent disability, then of course you'll be entitled to huge compensation. We've noticed that a lot of people, when they take their sick pay, they feel that that is the only right that they have. You can still claim your sick pay and say pursue the employer for compensation. And above all, I have also explained to people that they should not be scared to come forward to claim those compensations, because the employers are in business for profit. And there is no sympathy here, because employers have insurance, just like when we drive on the road, we have car insurance. So it is not the employer who is going to be liable to pay that compensation. It is the insurance that they have that will cover you for your injuries once you are at the workplace. So there is no need to be terrified to make a claim or to show sympathy to the employer by not claiming the compensation. And above all, you cannot also be dismissed simply because you have made claim for personal injury compensation. Simply because if the employer ever did that, it should be either unlawful or unfair dismissal or breach of contract. Now, under those bases, you will also be entitled to huge compensation depending on how many years that you work for the employer. So you are in the game both ways. So I will entreat people not to be scared. And at the gym, I also said that they are owed a duty, that premises are safe and people there are trained to assess them to do the exercise without incurring any injuries whilst they are there. And if ever happen, then they are also entitled to compensation. This is what we discussed tonight.
Thank you very much, Lawyer Thomas Beyebenwo from City Law Solicitors, for educating us, throwing light on personal injuries at work and at the gym. It's been very educative. And then for you viewers, thank you very much, and listeners as well, for being part of this program. I hope you enjoyed it. I've learned a lot tonight, and I know what exactly to do when there are issues of that at the gym or at my workplace. So thank you, Lawyer, and City Law for being our backbone, for City Law Solicitors for being our backbone for this educative program. So next week, Tuesday, we'll be here, and then Thursday as well from 8:30 p.m. So watch out for the links. If you get any notification, please make sure you share for others to benefit as well. And then, of course, outside the studio, we've got, obviously we've got the radio 24 hours on with good music, which I have selected. And of course, you enjoy everywhere you are. So please make sure that you enjoy this community, extensive community that we have brought. City Media is there to support your legal matters as well. Of course, your entertainment is assured as well. Thank you very much. My name is MC Chaka. I've been your host for this insightful and educative program. Until we meet next week, I'll say bye-bye to you for now. Have a good evening. Thank you.